Yeah.
I'll run there. If you can't hear and it's not on, just, you know, make a signal.
This one,
Yeah, it sounded pretty good.
it's really good if it.
Next one out there.
Yeah. Is that hot? Sort of hot?
Okay.
Billy, I think that's the way to live. They run a mobile trailer, so we gotta go out and use that.
Brad. Hi, Joe. What's going on, man? Just hanging out. Kind of. It's good looking. What's up, buddy? I got a free trial with Sarah.
I think that'll work pretty good.
This Sarah? Yeah.
The real phone. That's it right there. That's it.
Yes, it's not.
Which case?
It's not such a type all the time. But not the whole side.
Hey, I'm in 18B. Sorry, appreciate it.
With who?
Yep. Brittany here, Anthony there, Hakeem there.
I had him hold it. I had him hold the base.
Can the judge see counsel in the back, please? And I think that I need to get them out of there.
Sarah was going to sign something.
Okay. Okay. That's okay. It's your ETA. That's okay. Oh, okay. Then you won't, then we'll wait for you. Thank you. I just wasn't, no, that's okay. I just wasn't sure. And he relayed that. problem, don't worry, thank you. Listen, no, logistically, it's perfect timing. Just, all right, thanks. Thank you.
Oh, shoot. Yeah, I'm messing up with my delicacy. It's coming.
Could be wrong.
Details go there.
Yeah, I mean,
Absolutely, do whatever you need to do. Thank you, Dave.
You're welcome.
What's your VP? They're gonna start bringing them in and, we're gonna get started.
Folks, for everyone's there in the courtroom, please make sure your cell phones are turned off. You know, those are not used now. We also go to the
Yeah.
Thank you.
One more time for everyone, just make sure all phones are off. Just want to make sure everyone's-
We're still waiting on one of the candidates, so perfect timing. Good morning, Amy. This is Judge. All rise. Court of Common Pleas now in session. The Honorable Mollie and Murphy presiding. Thank you. Please be seated.
Good morning. Today is January 7th, 2026. We are here in case number 670878, defendants C, D, and E. If the parties could please identify themselves for the record, starting with the prosecuting attorneys.
Thank you, Judge. Kevin Filiatro, Assistant Prosecutor on behalf of the state.
Megan Hoffman on behalf of the state of Ohio. Special Agent Kristen McCaskill, FBI.
Jay Schlackett on behalf of Britney Smith.
Maxwell Martin on behalf of Britney Smith.
Thomas O'Shaughnessy on behalf of Mr. Bryant. Brian Fallon on behalf of Mr. Bryant. Brett Jordan on behalf of Mr. Shomo.
Thank you. We are here for sentencing in this matter. Any reason this court should not proceed, Mr. Filiatro?
No, the state is prepared, Judge. Thank you.
Mr. Schlatt?
No reason.
Mr. Martin?
No, Your Honor. No
Mr.
reason.
Shaughnessy?
No, Your Honor.
Mr. Fallon?
No, Your Honor.
Mr. Jordan?
No, Your Honor.
Thank you. On October just one moment, please. Ms. Smith, on a previous date, entered a plea of guilty to count 1, aggravated murder, with the 3-year firearm specification in violation of 2941.145, an unclassified felony. Strike that. The defendant was found guilty of aggravated murder with the 3-year firearm specification in violation of 2903.01, which is an unclassified felony. Additionally, Ms. Smith pled guilty to conspiracy in violation of Ohio Revised Code Section 2923.01A2, which is a felony of the 2nd degree. As it relates to Mr. Bryant, on October 31st of 2025, a jury returned a guilty verdict as to aggravated murder in violation of 2903.01A. Also found the defendant, Mr. Bryant, guilty of murder in violation of 2903.02B, an unclassified felony. Next, the jury found Mr. Bryant guilty of felonious assault in violation of 2903.11A1, a felony of the 2nd degree. Next, the jury returned a verdict of guilty to felonious assault in violation of 2903.11A2, also a felony of the 2nd degree. Next, the jury found the defendant guilty of aggravated murder in violation of 2903.01B, an unclassified felony. Next, kidnapping in violation of 2905.01A1, a felony of the 1st degree. Again, the next count being count 8, kidnapping in violation of 2905.01A2, also a felony of the 1st degree. The jury returned a guilty verdict as it relates to count 9, again, kidnapping in violation of 2905.01A3. And also a guilty verdict as to conspiracy in violation of 2923.01A2, a felony of the 2nd degree. Counts 10 and 11 were nullified or dismissed by the state of Ohio. The jury also found Mr. Bryant guilty of the 1-year and 3-year firearm specifications as it relates to counts 1, 2, 3, 4, 5, 6, 7, 8, and count 16. The jury found the defendant, Mr. Bryant, not guilty as to count 9. Moving on to Mr. Hakeem-Ali Shomo. The jury returned a verdict and found Mr. Shomo guilty on November 25th of 2025. The jury returned a verdict of guilty of aggravated murder in violation of Ohio Revised Code Section 2903.01, an unclassified felony. Additionally, Mr. Shomo was found guilty of felonious assault in violation of 2903.11A1, a felony of the 2nd degree. Next, guilty of felonious assault, again in violation of 2903.11A2, a felony of the second degree. Mr. Shomo was also found guilty of aggravated murder in violation of 2903.01B, an unclassified felony. Additionally found guilty of counts 6 and 12. Guilty of murder in violation of 2903.02B. Next, Mr. Shomo was found guilty of kidnapping in violation of 2905.01A1, a felony of the first degree. Next, count 9, kidnapping in violation of Ohio Revised Code Section 2905.01A3, a felony of the first degree. Counts 10 and 11 found guilty of kidnapping in violation of 2905.01A2. The jury also returned a verdict of guilty of conspiracy as it relates to Mr. Shomo in violation of 2923.01A2, a felony of the second degree. The defendant did bifurcate, and this court found the defendant guilty of having weapons while under disability in violation of 2923.13A2, a felony of the third degree. The jury also returned a verdict as it relates to Mr. Shomo of not guilty as to murder in violation of Ohio Revised Code 2903.02B, and also found Mr. Shomo not guilty of kidnapping as charged in count 8 of the indictment. And also, for the record, the jury found the defendant, Mr. Shomo, guilty of the 1- and 3-year firearm specifications as outlined in counts 3, 4, 5, 6, 7, 9, 10, 11, and 18 of the indictment. The court is in receipt of 3 sentencing memorandums. The State of Ohio filed a sentencing memorandum with this court yesterday, January 6th of 2026. Additionally, Mr. Phelan, on behalf of his client, filed a sentencing memorandum on January 6th of 2026, and Mr. Schlaget and Mr. Martin filed a sentencing memorandum on December 24th of 2025. The court has reviewed those and has read all of those sentencing memorandums on behalf of the State of Ohio.
Thank you, Judge. Your Honor, if counsel for Mr. Bryant and I could approach.
Of course. Thank you. Thank you, Mr. Filiatro, Mr. Shaughnessy, and Mr. Phelan. The court misspoke and the court will correct itself. Mr. Bryant was found guilty of kidnapping in count 9, not in count 8. On behalf of the state.
Thank you, Judge. Your Honor, with regard to defendants Bryant and Shomo, The state mentioned this in the sentencing memo, and I'll mention this on the record here. We do need to discuss the issue of merger of offenses with regard to those two defendants only. Merger will not apply to defendant Britney Smith. With regard to these cases, Judge, the state concedes that the homicide and assault offenses will all merge for each defendant, and the state is electing to proceed to request a sentence on count 1 for both of them, for both Anthony Bryant and Hakeem Shomo. And I think it's the easy way to discuss it is just to say the homicide offenses, so all counts of aggravated murder and murder, as well as assault offenses, so both counts of felonious assault, they all merge into count 1 for both defendants. With regard to the kidnapping counts, there's a different discussion with regard to each of the defendants. With regard to Anthony Bryant, all kidnapping counts will merge into count 9. And we're requesting a sentence on count 9. For Mr. Shomo, all kidnapping counts for Alishah Pointer will merge into count 9. But counts 10 and 11 do not merge because they have different victims. And that's Ms. Jackson and Ms. Harris. So the state of Ohio is requesting sentences on counts 1 and 9 for both Anthony Bryant and Hakeem Shomo, and the state is also requesting sentences on counts 10 and 11 for Mr. Shomo. Finally, with regard to Mr. Shomo, he had one count of having a weapon under disability. That also does not merge with any other offense. So when it comes to, and I also should mention, the conspiracy counts, those counts by operation of law must merge with a completed offense for which the conspiracy was alleged. So in those counts, there were counts of conspiracy to commit kidnapping of Alishah Pointer. Because they were both found guilty of the completed kidnapping of Alishah Pointer, in count 9, that's the count that we're requesting a sentence on, they cannot be sentenced on the conspiracy counts either. So for Mr. Shomo, Mr. Bryant, we're requesting sentences on counts 1 and 9. For Mr. Shomo, also counts 10 and 11. With regard to firearm specifications, under the law, the court must get, because they were found guilty of several felonies. And because one of those felonies is aggravated murder, and they both were found guilty of multiple 1- and 3-year firearm specifications, this court must, under 14B1G, this court must give sentences for 2 of the 3-year firearm specifications. It may, in its discretion, give sentences for more than 2, which would only apply to Mr. Shomo. Because with regard to Mr. Bryant, well, it could apply to either one. We're not asking for a sentence on more than 2 anyway. So with regard to merger, I've discussed merger of offenses, and I've discussed firearm specifications.
And Mr. I do not mean to interrupt, but do you agree with that statement, Mr. Schlager, with regards to merger?
It
Those
doesn't apply to us.
statements, thank you, Mr. Schlager. Mr. Chauncey,
We agree, Judge.
Mr. Fallon,
Yes, Your Honor.
Mr. Jordan,
Yes, Your Honor.
thank you. Thank you.
Thank you. All right. Would you like the state to then proceed with the
Yes,
sentence?
please, thank you, Mr. Valiato.
Thank you. Your Honor, you've read the state sentencing memorandum. The offenses committed against Alishah Pointer and Turquoise Jackson and Tashera Harris are completely and utterly heinous offenses. And they happened in 2021. And we are finally here now in 2026, ready for the completion of this case with regard to these 3 defendants. With me in court are members of Alishah Pointer's family. And I know this court has seen them every day of the 3 trials this court held for these 3 defendants. And they are here again today. And I would like to have 3 of them speak if it pleases the court.
Certainly.
I'm going to begin with Alishah's mother.
Thank you. Good morning.
Good morning, Your Honor.
If you could please state and spell your name for the court reporter.
Erica Pointer, ERICA-POINTER.
Thank you, and whenever you're ready.
I've had 4 agonizing years to have this opportunity to speak about the murder of my child. I know all of my words will go on deaf ears to her murderers, as they possess no human decency. They have told lies in order to justify their crime and try to assassinate her character. No matter how many lies they tell, it will never be a fact. My daughter was innocent and did not deserve this. I like to share with you who she really was. She was beautiful inside and out. She was special, loved, and was full of love. She was not trash to be thrown in a pile of filth and laugh. She had the most beautiful smile and an even bigger laugh. She had a caregiver's heart, which was why she was in the nursing field caring for everyone. She also spent many years caring for children in the daycares. She always told me that she just liked to see the good in people. She was always the person there to lend a helping hand and a loving heart. Britney experienced that firsthand as she gave her comfort, food, love when Britney's own daughter was missing. And I just can't fathom how within months she joyfully took my daughter's life. Alishah had plans. I still have her journal with all of the things she wanted to accomplish. She was enrolled to begin a certification in teeth whitening, and she wanted to start her own business. They robbed her of a promising future. She never got the chance to have children, get married, or fully enjoy her life. They robbed us of creating more memories with her, chances to support and be proud of all of her accomplishments. We never got the chance to tell her happy birthday the day they joyfully brutalized and murdered her. She never got a chance to meet her niece and nephew. They have to see her through pictures and visits to her gravesite. My 4-year-old grandson today saw my shirt and asked, "Are you going to see TT Tammy today?" It's so beautiful that he knows and loves her without ever setting eyes on her. But it's heart-wrenching at the same time because of that. When they murdered my baby, they killed off a piece of everyone that loved her. They have forever impacted our daily lives. There's a battle inside of me that I fight every day because my mind knows that they murdered her, but my heart just won't believe it. I still can't believe she's gone. The day I was told she was missing, I was in complete denial that day. I didn't want to believe my baby was missing. As the sun came up, I felt the sickening in my body. I knew she was gone. And when I heard those words on November 9th, I felt and heard the break inside of me. I am filled with so much anger, hate, rage. It's unhealthy. They did this to me. I didn't ask for this.
Take your time.
I struggle to get up every day. I'm still so confused. Same question placed in my mind all day long. How is my baby doing? What's inside of these monsters cannot be rehabilitated. They are incapable of feeling empathy and remorse. Not one person showed my child compassion or mercy, and I beg for this court to not show them any mercy and hand down the strictest sentence possible. Thank you.
Thank you, ma'am. I'm very sorry for your loss. Thank you for your time. Good morning.
Good morning.
If you could please state, and these fans are quite loud,
Okay.
please keep your voice up. Can you please state and spell your name for the court reporter?
Hi, my name is Alishah. It's Alayshah Pointer. I'm Alicia's older sister. I didn't have nothing, written down. I'm just going on strictly my emotion. Growing up, when you're the older sister, you're always compelled to take care of and to protect your siblings. And I can't count on my hand how many times I've protected my siblings from danger. And in this instant, it felt like this, and it was one of those things that were out of my hands that I couldn't get here in time. I couldn't be here to save my sister. And I wake up to the thought of that every day because I spent 21 years protecting my siblings as the older sister. Every day I wake up, it was me, my mom, Aaliyah, and Alishah, always in that house. It's unreal that it's me, my mom, and Aaliyah. It's always been four of us, and I don't know how to explain watching my mom grieve. I don't know how to explain watching my sister grieve. And even then, while I'm grieving, I still feel compelled to protect my family, their emotions during this time. My sister was somebody that would have gave the shirt off her back. My sister has helped many people with their children. My sister has helped many people take care of their children, find their children, bring their children to safety. So for somebody to come take my mother's child will never sit right with me. And with my sister passing, it's opened my eyes to so much, not just physically, but spiritually. And in knowledge that my sister may be physically gone, I see her every day spiritually. And she tells me that everything gonna be all right. That not only is she with God, but she always here. You can take somebody physically, but you can't take them spiritually. And she gonna always be here with us through everything that we've been through these last 4 years and beyond. I just
Take your time. No, you're fine. Take your time.
My sister, like my mother said, my sister saw the good in everybody. Even if they was the worst type of person. My sister didn't see you for how other people saw you. She saw you for how she felt about you, for what you were capable of, even when you didn't see it. My sister was somebody that was working on herself. She was getting ready to start her business. Getting ready. She was starting her dental business. My sister wanted to sell clothes. My sister had so much she wanted to do. And she was on the verge of getting it done, and that was stripped away from her. Her life was stripped away from her. Her life was stripped away from her family. Everything that she wanted to do was stripped away from her. Nobody considered anything when approaching my sister with a situation like this. No one considered the aftermath. No one thought twice about it. And now we're here today with the aftermath. So, that's all I have to say.
Thank you. I'm sorry for your loss.
Thank you.
Thank you. spell your name for the court reporter.
My name is Alishah Pointer, AALIYAHPOINTER. I wrote mine down because I get lost in the words sometimes with all of this. Losing my twin sister is a loss that cannot be measured or repaired. From the moment we were born, we shared a bond deeper than any other relationship in my life. Tammy was not only my sister, she was my other half, my best friend, and the person who understood me without words. To lose her on our birthday just makes things worse. Every year is a recurring nightmare. Tammy was one of the kindest, most supportive people I have ever known. She was the sweetest soul, always putting others before herself. The smile she had, I know, made many people's day. My sisters and I can all agree that Tammy put us first most days before herself. She was a great listener and a steady shoulder to lean on to her family and the friends we shared together. Before this crime, my life was stable. I went to work without issue. I slept through the night. I trusted people. I felt safe in the world around me. Since this crime took place, all of that has changed. At the time of this crime, I was pregnant with my son. Tammy was overjoyed about becoming an aunt, and she was supported through my pregnancy. She checked on me constantly and shared my excitement. Knowing that my son and now my daughter will never truly know who she was deeply saddens me. When I look at my children, I see her. I also carry the painful knowledge that one day I will have to tell them who Tammy was and why she is gone, and I imagine how they will react. That future conversation weighs heavily on me. And since this crime, my emotional and psychological health has been severely affected. I have been diagnosed with PTSD and anxiety, and I experience depression that seems to sneak up on me without warning. I have nightmares with flashbacks and panic attacks. When I wake up from my sleep, I sometimes stop breathing, and I feel like I'm dying. And this seems to happen when I'm mostly alone. Sometimes I feel like I'm living Tammy's trauma. I never feel like I'm carrying my own. And when I'm out in public or at work, people know who I am and what happened, and that is scary. For me, I constantly have to bring my personal life into work, everywhere I go, really. There are times when I feel unsafe. I do not know who knows the people responsible for this crime, and that creates constant fear. Sometimes I feel like someone may be out to get me. Even at night, I have recurring dreams involving the defendants, Hakeem, kidnapping me or trying to get Tammy away, visions of her last moments. And when I'm out in work or public, it's like these images intrude, making it real difficult for me to focus at work or anywhere. And Tammy's death has permanently altered my life. I grieve not only who she was, but the future she was denied and the life we were meant to continue together as twins. This loss has changed how I sleep, how I work, how I trust, and how I move through the world. Tammy's life had value. She was deeply loved, and her absence has caused lifelong pain for those of us left behind. While nothing can undo what has been done, accountability matters. And I ask the court to consider the depth, permanence, and the ongoing impact of this loss when determining the sentence. Thank you.
Thank you very much. I'm very sorry for your loss. Thank you, Ms. Pointer.
Judge, I just have a few more comments from the state of Ohio, if I could. This crime was a coordinated effort by these three and others to get revenge. To get revenge for the murder of Alishah Shomo who is a loved one, as we proved, of all of the 6 defendants, and probably, and definitely, many more people. But as you just heard, Alishah Pointer is a loved one of at least all of them, and more. None of that mattered to them. None of it. And they all knew what they were going to do before they did it. And that's what we want. We ask this court to sentence and to acknowledge in the sentencing of these 3 defendants. Hakeem Shomo knew exactly what he was doing when he and the others felt that they had solved the crime of the death of Aminjas. He knew what he was doing when he set out with the others, and they went looking for that individual. Couldn't find him. So then they went looking for his girlfriend. And they went to a location they thought first, where she wasn't, but they kidnapped those 2 people. As a means to an end, we're going to take these 2 to find somebody else. And they did that. And then they get her. And what did they do? Hakeem Shomo, Anthony Bryant, and Britney Smith, all of them, wanted her to suffer. Imposed suffering on Alishah Pointer as leverage to get the other person they were looking for to come out. And you heard at trial, you heard one of defense counsel trying to argue that they just wanted to talk to that person. They just wanted to get him and question him. No. This was all about trying to find someone so they could kill that person. When they couldn't find that individual, they did that to Alishah. Hakeem Shomo knew when he brought in the real hitters, Alishah was going to die. He left that house and went and made an alibi for himself hours before she was dead, because he knew what was going to happen. That's his prior count. He brought in the murderers, and he left and made an alibi for himself before it even happened. Anthony Bryant brought his gun with him when he was called in. We know what he said to people before he went. He agreed, yes, I'm ready to blow her head off. And that's exactly what he did. He was Alishah Pointer's chief executioner, Judge. He used both guns at that scene. Britney Smith, when Hakeem Shomo called her in, she, and as this court knows, we proved during her trial, she, in the next several minutes, feverishly looked for a ride to what she was calling a surprise party. She knew this was Alishah and her twin sister's birthday. She needed to get to a surprise party. One of the cruelest ironies in this case is that Alishah Pointer spoke to Hakeem Shomo over Instagram without ever knowing he was coming for her. Her twin sister spoke to Anthony Bryant over Instagram, begging for information as to the whereabouts of her sister, without ever knowing that person was about to murder her. Your Honor, for these defendants, we seek the maximum penalty. Hakeem Shomo, Anthony Bryant should receive life without parole. They should also receive sentences for the kidnappings they committed as well. Britney Smith took responsibility on the last day of her trial. As part of her plea, we agreed we would not seek life without parole. So, we seek the maximum regardless of that. Her maximum is 41 to life, Judge. What they did to Alishah Pointer was coordinated, thought out, and vengeful. Nothing about it is mitigatory for them. We ask this court to acknowledge that and sentence them accordingly. Thank you.
Thank you, Mr. Filiatro. On behalf of Ms. Smith.
May it please the court, Your Honor, I'm certain that Mr. Martin will have some comments, and we are going to encourage, we'll hear from Britney, who's going to allocate on her own behalf. Judge, the only advantage that we have in this is that you were able to hear 3 trials. In effect, Britney's trial was completed when she accepted full responsibility, which she got a benefit for, as Mr. Filiatro indicated. The plea agreement removed the exposure of life without parole. She pled to a conspiracy without a firearm specification. So she's exposed to 20, 25, 30, plus the 3. And that's all the minimums because it's life imprisonment, and it's up to the parole board. And Judge, in your vast experience, you know it's hard to predict what will happen 30 years from now or 25 years from now, but today, that parole board is not letting anybody out, especially on a case with facts that could be interpreted to be egregious. You heard Britney's conduct juxtaposed to the other's conduct. At trial, there was evidence that she wasn't even in the basement when the shooting occurred. No one put a gun in her hand. No one had her shooting anyone. But she's involved, she accepts responsibility, and I don't say that to say, she's innocent. She, of course, is not. And she knows it, and she's going to have to live with it the rest of her life. Your Honor, when you consider all the factors of 29, 29, 11, 12, 13, and 14, Mr. Filiatro is suggesting that perhaps a consecutive sentence on a conspiracy should be imposed. I submit to you that the factors of 29, 29, 14 are not applicable in this case. If you look at her record, Your Honor, she's 36 years old. I think she's going to be 37 in a couple days. Her only prior criminal history whatsoever is receiving stolen property back in 2011, where she successfully completed probation. Now, I don't say that you should canonize her for that. Nobody's supposed to have a felony conviction. But it is indicative that she is not a lifelong criminal. There was a set of unique, unexpected facts that were intertwined and then just started to play out in this case. And she dearly loved the young man who was killed, and she absolutely went about seeking justice the wrong way. She had no faith in the police department of East Cleveland and thought that nobody was going to care about her, who she considered to be a son, who the system considered just another throwaway inner city kid who got killed. But to her it was more important, and she did everything she could and did it all the wrong way. And she's going to live with that the rest of her life. She's going to apologize. I'm certain the family's not going to accept it. She understands that. And the emotions are too raw. But Judge, I submit to you most respectfully that if you consider all the factors of sentencing, and if we can get past some of the inflammatory facts and the remarks of the state, just looking at the statutory factors, she should receive a 20-year sentence plus the 3 for the firearm specification, which is 23, with a concurrent for the conspiracy. And that, of course, judges, again, that's life with only the eligibility after however many years you impose. We submit 23 is appropriate. That doesn't mean she gets out. She may never get out. And she's going to be probably in her 60s, just by the parole board's actions. So we ask, Your Honor, that consider the 23. It would not demean the seriousness of the crime. It could adequately punish this offender, and it can ensure that when she gets out, she'll be properly rehabilitated. Thank you, Your Honor.
Thank you, Mr. Schlatt. Mr. Martin.
Yes, thank you, Judge. And just very briefly, I know you've heard from Mr. Schlatt, and I endorse all the comments that he's made. I want to supplement his arguments by first and foremost acknowledging the loss that the Pointer family has suffered. I want to also acknowledge and Schlackett's and Ms. Smith's deepest sympathies to those folks gathered here today. I also want to acknowledge the grace and composure that they've shown, not just today, but throughout this process. They've been here consistently, and we recognize that, and again, are just very terribly sorry for their tragic loss that is unfathomable. What you will do today, Judge, will represent justice, but it won't bring back Alishah, and we know that. So when we ask for a 23 to life sentence, it's not asking for lenience, it's not asking for forgiveness, because that's not what this is about. Ms. Smith is ready to, and has accepted responsibility. She is ready to apologize. Just to put a finer point on an argument made by Mr. Schlackett, we're not asking for 23 years. This is a life sentence. You will impose a life sentence today, Judge. Ms. Smith has known that since the moment she said, "I am guilty." What that means is that she will go in front of a parole board in however many years you say, Judge. Mr. Schlackett says that not many people get parole these days, and that's true. The ODRC's annual report, the most recent one from 2024, tells us that in 2023, the parole board performed 898 release detention hearings, and 113 people were granted release. The year before that, 1,013 people came before the parole board, and only 114 people were granted their release. Judge, we trust your judgment. You will make the right call today, we know that, but no judge possesses a crystal ball. No judge can tell now, sitting here in 2025-6, when a person will be rehabilitated. But you know who can? The parole board. Let's empower them to make that decision 23 years from now, which is a significant amount of time. Who is in the better position? And I say this with all respect, Judge. They'll know things that you can't know today. They'll know whether she's done the hard work that she says she's going to do to make amends and rehabilitate herself. The prosecutors acknowledge that Ms. Smith has accepted responsibility, and what better way to show her first step towards rehabilitation than that acknowledgement and acceptance of responsibility. Because she's done that, she's allowed herself to get a chance at the parole board, Judge, and we're hopeful that you will allow them to do their job at the appropriate time. We believe that to be in 23 years' time. Judge, if now is the appropriate time, Ms. Smith is prepared to make a statement to you.
Certainly.
Thank you, Your Honor.
Thank you.
But there are no words I could string together that could assuage the pain of the awful tragedy, so I would just say my piece. I wasn't thinking. Emotions were running high from the death of my loved one, Minjaz. One thing led to another and things tumbled out of control. It could have went, it never had to go as far as it did, and for that I'm deeply sorry. No, I'm not the shooter nor the kidnapper, but I still share responsibility. My silence, not speaking up, cost Alishah her life. Not one day goes by that I don't think about her and how I could have saved her. Every night I toss and turn with the guilt of an innocent losing her life, and I wish I could take it back. I have failed my family, my children. Now my children will grow up without their mother and father. I am now a burden to them, whereas I once was a champion for them. I hope to be reunited with them one day, and that my grandma makes it to the other side of my sentence. I pray that the Porter family can one day find it in their hearts to forgive me, that our Heavenly Father will comfort each one of them in the days, weeks, and years to come, and will heal their hearts and give them peace. I'm sorry.
Thank you, Ms. Smith.
Thank you, Judge.
Thank you, Mr. Harden. Thank you, Mr. Schlatt.
Thank you, Your Honor.
We have Mr. Bryant.
I'll be somewhat brief. I know that you read our
Take your time.
sentencing memorandum, and there's a couple of things I would like to point out to the court under the relevant sentencing statutes. Mr. Bryant, prior to this event, had no criminal record, and he's 18 at the time that this happened. He was grieving because his friend, Alishah Shomo, had been murdered. He was his best friend, and he was grieving to the point where he actually didn't participate in the original kidnapping. He wasn't present for that. So his involvement came in, according to witnesses, later than that. However, none of this is excusable. And I'm not saying this for purposes of excuse. I'm just pointing things out that are required for this court to look at under the sentencing law in Ohio. So you have an 18-year-old man that was overcome with grief. He had no prior record. I think You know, the court has heard all the testimony in this case. You sat through 3 trials. You heard all the witnesses. So you're intimately familiar with this case. It's a tragic case all around. Our sympathies go to the family of the victim. And the family, anytime a family has to show up in court and listen to this, it's horrendous. And this case was obviously horrendous to listen to. What I'd ask the court to do is to be mindful of the defendant's age and his circumstance in this case. I think he was really in a position where he might have been subject to direction of others besides his own anger. And I'd ask the court to take that into consideration as well. As the court knows, he's subject to getting, prosecution's asking for life without parole. We're also asking for a consecutive sentence on one of the kidnappings. And I would suggest to the court that a consecutive sentence with a life tail is somewhat meaningless. And I would ask the court to consider not making a consecutive sentence here. I realize there's going to be at least 2 gun specs that the court would put on. I would ask the court to sentence him on the aggravated murder charge as something less than the maximum. I think there are other people in this room that were actually more involved, and I think from listening to the case and trying this case, as I argued to this court, there's other people involved that never saw the inside of a courtroom. There's a number of people involved that totally got a pass on this thing. All that being aside, Your Honor, I'd ask the court to consider something less than the absolute maximum in this case and not impose a consecutive sentence. It's going to be serving a very lengthy sentence, whatever sentence this court gives. As a young man, his life is basically ruined. His mother and aunt are here. They would at some point, if the court cares to hear from him, like to address the court. So that's what I'm asking the court for.
Thank you, Mr. Fallon. And at this time, all cell phones in the courtroom must be turned off. There can be no recording of these proceedings. Mr. Fallon, at this time, the court is prepared to proceed from the individuals that would like to address the court on behalf of Mr.
Good morning, Your Honor.
If you could please state and spell your name for the court reporter.
My name is Shanti Jackson, C-H-A-N-T-E.
Whenever you're ready.
I am Anthony Bryant's mother, and I don't know what was going on, and I still don't know. All I want to say is to the family, and I know them having to deal with trial after trial after trial might have been very horrible for them, but I just want them to know I pray for her every night. And I'm so sorry. I truly am. No one deserved to lose their life, and I'm not saying what my son was involved was his right. His life, everybody's life is being taken away from him now because of this senseless crime. But I just want the family to know that I'm truly sorry for their loss.
Thank you for your time. Mr. Fallon.
Good morning.
You could please state and spell your name for the court reporter.
Patricia Johnson, Patricia Johnsson.
Whenever you're ready.
I never would have thought that I would be here ever in life. Anthony Bryant is my nephew's son.
that I helped to raise as he was growing up. I got to see the real him, the potential that he has had in his life. To the family, my heart aches for you all. Can't imagine. I'm not going to pretend to imagine what they are suffering. But I will tell you that my prayers are with this family. No one wants to lose a loved one and to lose them in such a tragic manner. I do believe that there is an issue with our young people today, period. We have got to do better with guiding them in the right path. But I will say to you that we did the best that we could. Amen. We did the best that we could. And I love my nephew with everything in me. And I'm asking you to please consider, as his lawyer said, his age at the time. It don't excuse it, but it do put an impact on that thought process at that time. Not excusing it, please understand me, but I believe that he has already suffered. It's been since 2021 up until today. I believe there has been some suffering, not only on his behalf, but on his family's behalf, because we didn't see this coming. Nobody sees something like this coming unless you are raising them to be such an individual. Yes, there was some influence. Yes, there was. Yes, they should be held responsible because these are young people and you should have been guiding them in the right way, not helping them to ruin their lives. I mean that from the bottom of my heart. So, Judge, please consider my nephew to be influenced to do such a heinous crime. Thank you so much.
Thank you for your time.
Good morning.
Can you please state and spell your name for the court reporter?
My name is Sharon Jackson, S-H-A-R-O-N, Jackson, J-A-C-K-S-O-N.
Take your time. Whenever you're ready.
I am Anthony Bryant's grandmother. In many, many years, I would never thought we would be going through something like this. He was a loving kid growing up. It's just that he got pulled into the wrong direction and led down the wrong path. I'm just asking you to spare his life without parole. And not only did Ms. Pointer family suffer, we all are suffering because it's like his family done everything too. Thank you.
Thank you. Mr. Fallon, any additional individuals?
There's one more, Judge.
Thank you. name for the court reporter.
Chanel Rudolph, Chanelle, Rudolph, Rudolph.
And whenever you're ready.
Well, situation I'm on is just overtaking for everyone. Emotions is very high. I do apologize for the victim's family, first and foremost. Like my mom and my aunt and my sister and everyone touch bases, everyone is affected by the decisions that was made amongst everyone. Let alone my nephew. He's a good kid. And he had dreams as well. He decided to go down the decision path where he was influenced, like people said. He is an amazing kid. And just to be thrown into the light of seeing something of an image that was never portrayed, to see out of him is the most, it's the hardest thing to watch. But they say life with parole is it's too long. It's too long, and I know it's going to be longer for their family as well, but it's time that we all cannot give back. And I do feel like he does deserve a second chance because he's not a bad kid. And he does deserve an opportunity to show you guys as well to the potential rehabilitation that he does have with the sentence. But life with parole it's a lot. It's a lot to take in, and I truly am sorry for the Pointer family. And words cannot bring her back at all. That's all I do have to say.
Thank you for your time. Thank you. Anything further on behalf of Mr. Bryant, Mr. Brown?
Briefly, I know the court's aware of what the offer was to begin this case. We're really almost in the same position, quite frankly. Again, I ask the court to consider something less than life without parole maximum. And I think my client at this time, I can let him address it himself, but I think he wants to preserve all his appellate rights. And I think he will choose not to help this time.
Thank you, Mr. Brown. Mr. Chauncey?
I have nothing to add, Judge.
Thank you. And Mr. Bryant, is that accurate? You do wish to invoke your Fifth Amendment, right?
Yes, ma'am.
Thank you, Mr. Bryant. Mr. Jordan, on behalf of Mr. Shomo.
Thank you very much, Your Honor. I'm going to try not to reiterate what everyone else has
Take your
said.
time.
In essence, Judge, we know that this court has to impose a life sentence. There's no two ways about it. The only question that we have here today, Judge, and the question that you have to answer is, are you going to give Hakeem a chance to get out on parole? We're not talking he's getting out in 5 years or 10 years. We would ask for a life sentence, possibility of parole at 25 years, plus the 6-year gun spec makes it 31 years, Judge, before he's even eligible to see the parole board. He's 34 years old now. He'll be 65 years old at that time before he even sees the parole board for the very first time. As you've heard the statistics, he's not likely to get out at 65. A 10-year flop puts him at 75 years old. The ability for someone to live in a prison for that long and at 75 years old is not very high. So in essence, that is life without parole. At that point in time, I'll be in my 90s, hopefully still arguing cases. But Judge, the difference that I'd like you to consider here today is the fact that, and it's undisputed, Hakeem was not there when she was murdered. Hakeem did not have a gun in his hand and fired that gun on that day. He wasn't there. There's a difference between being part of a plan and actually executing the plan. There's a totally different mindset. Now, we understand that the jury found him guilty of being part of the conspiracy, being part of the aggravated murder. We respect, but we do not necessarily agree. There were 4 other people there at the time. They made the conscious decision to fire a gun and to kill somebody. Hakeem was not there. He was not part of the conversation. He was not a participant. And I believe that is a difference between the others who were there and actually fired those shots. So, Judge, I respectfully request that you consider imposing a life sentence with possibility of parole at 31 years. I believe it would be appropriate. It is in essence a life without parole sentence due to his age, but it gives him an opportunity and something to strive for while he's there, to be a better person, to make amends, to participate and be productive in whatever capacity that he can be. A life without parole sentence, Judge, leaves no hope. And when you have no hope, the mind does some very bad things. And I do not wish that on anyone. And I understand that I'm arguing for somebody who is alive. And Ms. Pointer is not. I understand that. But we also have to have some difference between what the jury found as to Hakeem and what juries have found as to the actual shooters. I advise my client not to make a statement. He will be filing an appeal. So at this point, he will not be making a statement, Judge.
Thank you, Mr. Jordan. I'm just going to inquire of Mr. Shomo, just for the record. Mr. Shomo, is that accurate? You're exercising your right to remain silent?
Yes.
Thank you, Mr. Shomo. Thank you, Mr. Jordan. Any individuals that would like to speak on behalf of Mr. Shomo?
No, Your Honor.
Thank you, Mr. Jordan. And I failed to ask, on behalf of Ms. Smith, any individuals present that would like to speak to the board?
I should have addressed that, Judge. That's my error. We do have family support here. However, no one is prepared or desirous of making it. I'm sorry. I may be incorrect. I may stand corrected. I'm sorry. If, with your permission, we'd like for Ms. Smith's sister to address the group.
Good morning.
Good morning.
You could please state and spell your name for the court.
My name is Courtney Tatum, COURTNEY,
And whenever you're ready.
I don't really have much to say. I just really came up here to give my condolences to the Pointer family. My sister is not a bad person. She had bad influences, even though the age of what she was. And like she said, she wasn't in her right mind. And everybody's affected. Their family is affected. My family is affected. Everybody else's family is affected. And I just want to give condolences. There's no words that I can say that would bring her back. And there's no words that I can say to justify what my sister did, because she was absolutely wrong. But my sister's not a bad person. She's not a monster. She just had a bad moment. And that was all. And I apologize to the family that it took so long for this to come to an end, and they have to go through grieving. And I'm glad that it can all come to an end and we can all start a healing journey.
Thank you for your time. Thank you. Mr. Remark.
That's all we have for you, Judge. I do want to acknowledge, though, that Ms. Smith has a tremendous support system, a lot of people that care a lot about her. Mr. Schleich and I both been in touch with several of those people. So I just want you to know that And some of them are outside because, as you know, the courtroom's full. But just know that she does have that level of support in her life and people that care very much about her. Thank you, Judge.
Thank you, Mr. Martin. Anything further on behalf of the state before the court imposes sentence?
I'd just like to say one thing. Insofar as the defendants and their family are asking for this court to acknowledge certain things and show mercy, I want to bring up one thing that was testified in one of the trials. Alishah Pointer was treated so badly that when given the chance, she didn't even beg for her own life. She begged for the life of her sister and that unborn child. That's all. Thank you.
Thank you, Mr. Fitzpatrick. Before imposing sentence, the court notes for the record that it has considered the record, the oral statements made here today, the plea negotiations, the victim impact statements, the sentencing memorandums that were filed on behalf of the state of Ohio and the defendants in this matter. The court must and has formulated its decision based upon the overriding principles and purposes of felony sentencing, namely to protect the public from future crime by the defendants or others, and to punish the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on the state or local government resources. To achieve these purposes, the court has considered the need for incapacitation, deterrence, rehabilitation, and restitution. The court must and has also considered the seriousness and recidivism factors relevant to the offense and the offender pursuant to Ohio Revised Code Section 2929.12. The court must and has ensured that the sentence being imposed does not demean the seriousness of the crime or crimes and the impact it has had on victims or victim, and is consistent with other similar offenses committed by like offenders. Finally, the sentence is not based upon, these sentences are not based upon any impermissible purposes, namely the race, ethnic background, gender, or religion of Ms. Smith. Do you understand that, Ms. Smith?
Yes, Your Honor.
Mr. Bryant, do you understand that?
Yes, Your Honor.
And Mr. Shomo, do you understand that?
Yes.
Thank you. For the record and for purposes of Reagan-Tokes, as it relates to Ms. Smith, the qualifying offense in your case applies to count 17. As it relates to Mr. Shomo and Mr. Bryant, the qualifying offense as it relates to Reagan-Tokes is applicable in count 9. At this time, the court is going to notify the defendants of the Reagan-Tokes advisements. Ms. Smith, did you just hear what I stated?
Yes, Your Honor.
Did you understand what I stated?
Yes, Your Honor.
Mr. Bryant, did you understand and hear what I just stated?
Yes, Your Honor.
Mr. Shomo, same question.
Yes.
Thank you. Just one moment, please. So this again applies to all 3 defendants, as there will be a Reagan-Tokes tail on a count in each case. The defendants are notified of the following: that it is rebuttably presumed that the offender will be released from service of the sentence on the expiration of the minimum prison term imposed as part of the sentence, or on the offender's presumptive earned early release date, as defined in section 2967.271 of the revised code, whichever is earlier. Next, that the Department of Rehabilitation and Correction may rebut the presumption described in Division B2C i of this section if, at a hearing held under Section 2967.271 of the revised code, the Department makes specified determinations regarding the offender's conduct while confined, the offender's rehabilitation, the offender's threat to society, the offender's restrictive housing, if any, while confined, and the offender's security classification. Next, that if as described in divisions B, 2C, 2i of this section, the department at the hearing makes the specified determinations and rebuts the presumption, the department may maintain the offender's incarceration after the expiration of that minimum term or after that presumptive earned early release date for the length of time the department determines to be reasonable, again, subject to the limitation specified in section 2967.271 of the revised code. Next, that the department may make the specified determinations and maintain the offender's incarceration under the provisions described in divisions B, 2, C, little I, and again, 2 little I of this section, more than one time, subject again to the limitations specified in 2967.271 of the revised code. Lastly, that if the offender has not been released prior to the expiration of the offender's maximum prison term imposed as part of the sentence, the offender must be released upon the expiration of that term. Do you understand, Ms. Smith?
Yes, Your Honor.
Do you understand, Mr. Bryant?
Yes.
Do you understand, Mr. Shomo? Thank you. We're going to proceed first with Ms. Smith. Just 1 moment, please. The court finds that prison is consistent with the purpose of revised code section 2929.11. As to count 1 aggravated murder, this court sentences Ms. Smith to a life sentence without being eligible for parole until serving 30 plus 3 years on the 3-year firearm specification. So the first time Ms. Smith will be eligible for parole will be after serving 33 years, and the institution can keep Ms. Smith for life. As it relates to count 17, conspiracy in violation of 2923.01A2, that is the felony of the second degree, that is the qualifying offense that the court was referring to earlier. The court sentences the defendant to a minimum of 8 years and a maximum of 12 years. Count 17 to run concurrently to count 1. Strike that. Count 17 shall run consecutively to count 1. And the court makes those consecutive findings pursuant to Ohio Revised Code section 2929.14C4B. The court finds that the consecutive service is necessary to protect the public from future crime or to punish the offender, and that consecutive sentences are not disproportionate to the seriousness of the offender's conduct and to the danger the offender poses to the public. And the court also finds, again, pursuant to 2929.14C4B, as in boy, at least 2 of the multiple offenses were committed as part of 1 or more courses of conduct, and the harm caused by 2 or more of the multiple offenses so committed was so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct adequately reflects the seriousness of the offender's conduct. And the court makes that finding. The court sat through, as indicated by both the prosecutor and counsel for the defendants in this matter, 3 separate trials and heard all of the evidence. Ms. Pointer was kidnapped, tortured, taped. She had a gun placed down her throat. Beaten. And then left after being shot in an abandoned house in East Cleveland. For those reasons, the court finds that consecutive sentences are appropriate for Ms. Smith. Moving on to strike that. Moving on to Mr. Bryant. The state concedes, as indicated earlier, that counts 1, 2, 3, 4, 5, and 12. Strike that. Counts 1, 2, 3, 4, 5, and 6 and 12 merge for the purposes of sentencing. The state, in their sentencing memorandum, elects to proceed on count 1, aggravated murder. The court finds that prison is consistent with the purpose of Ohio Revised Code Section 2929.11. The court imposes a prison sentence at the Lorraine Correctional Institution of life without the possibility of parole plus 3 years as to count 1. Further, the state concedes that counts 7, 8, and 9, counts 7, 8, 9, and 16 merge. The state elects count 9, kidnapping, in violation of 2905.01A3. The court again finds that prison is consistent with the purpose of Revised Code Section 2929.11. The court imposes a prison sentence at the Lorraine Correctional Institution of, as count 9 is a qualifying offense as it relates to rape and so the court sentences the defendant to 11 to 16 and a half years on count 9, plus the 3-year firearm specification. 3-year firearm specification must by law be served prior to and consecutive to the underlying sentence of 11 to 16 and a half years. The court further finds that count 9 shall be served consecutively to count 1 pursuant to Ohio Revised Code Section 29.14C4B, which is exactly what the court just read previously, and the court makes the same findings. The facts in this matter are completely horrific. Ms. Pointer was tortured and ultimately shot to death and left in an abandoned house. The court finds that pursuant to 2929.14C4B that consecutive sentences are appropriate for Mr. Bryant. Moving on to Mr. Shomo. Again, per the sentencing memorandum filed by the state of Ohio, the state concedes that counts 1, 2, 3, 4, 5, 6, and 12 merge for the purposes of sentencing. The state has elected, again, pursuant to their sentencing memorandum, to proceed to sentencing on count 1, aggravated murder. The court finds that a prison sentence is consistent with the purpose of Revised Code Section 2929.11. The court imposes a prison sentence at Lorraine Correctional Institution as to count 1, life in prison without the possibility of parole. Mr. Shomo was found not guilty of the gun specifications as it relates to count 1. Further, the state concedes, again in their sentencing memorandum, that counts 7, 9, and 18 emerge for the purposes of sentencing. The state has elected to proceed on count 9, which is also stated here in the court by Mr. Cuyahoga. finds that prison is consistent with the purpose of Ohio Revised Code Section 2929.11. The court imposes a prison sentence at the Lorraine Correctional Institution as to count 9 for a period of 11 to 16 and a half years, plus the 3-year firearm specification that must be served prior to and consecutive to the underlying sentence on count 9, which is the 11 to 16 and a half years. Next, as it relates to count 10, the court finds that prison is consistent with the purpose of Revised Code Section 2929.11. The court imposes a prison sentence at the Lorraine Correctional Institution of 11 years. As it relates to the 3-year firearm specification in count 10, that 3-year firearm specification will run concurrently to the firearm specification in count 11. Moving on to count 11, the court finds that a prison sentence is consistent with the purpose of, again, Ohio Revised Code Section 2929.11. The court imposes a prison sentence at the Lorraine Correctional Institution of 11 to, strike that. The court imposes a prison sentence at the Lorraine Correctional Institution of 11 years as it relates to count 11. In addition to the 3-year gun specification, which again must be served prior to and consecutive to the underlying sentence of 11 years on count 11. Further, count 11 shall run consecutively to count 9, in addition to the 3-year firearm specification in count 9. The court again finds that consecutive sentences are appropriate, again, for Mr. Shomo pursuant to 2929.14 C4B and also C. Again, the reasons this court has indicated as it relates to 2929.14 C4B apply to Mr. Shomo. I can't emphasize enough the torture that Ms. Pointer experienced by these individuals in addition to others. So those same findings apply as it relates to Mr. Shomo pursuant to 2929.14 C4B. As it relates to 2929.14 C4C, the court also finds that consecutive sentences are necessary as the offender, Mr. Shomo, has a prior conviction of robbery, which is an offense of violence. Just one moment, please. Moving on to count 20, Mr. Shomo. The court finds that prison is consistent with the purpose of Revised Code Section 2929.11. The court imposes a prison sentence at the Lorraine Correctional Institution as to count 20 of 3 years. There were no firearm specifications attached to count 20. Just one moment, please. Next, this court must advise the defendants as it relates to post-release control. For the record, Ms. Smith.
We don't think post-release control is appropriate considering she's going to be facing parole. We don't think it applies.
Thank you, Mr. Schleckett. Mr. Pilato, do you have a position on that?
Given that counts 1 and 17 were to be run consecutive, I think the advisement for PRC is valuable today, so I would request the court advise it. Whether it's imposed or not, may or not be the case at that time, but because it may be, I think the advisement's appropriate.
Thank you, Mr. Alishah, and thank you, Mr. Schlaggett. I am going to advise each defendant as to post-release control on the counts that it applies in an abundance of caution. So as it relates, Ms. Smith, to your post-release control, Ms. Smith, that applies to count 17, which post-release control carries with it a mandatory minimum of 18 months up to 3 years upon your release. It is mandatory. Do you understand?
Yes, Your Honor.
And Mr. Bryant and Mr. Shomo, post-release control as relates to your cases is mandatory. Should you be released and placed on post-release control, it would be a mandatory minimum term of 2 to 5 years on post-release control. Do you understand that, Mr. Bryant?
Yes.
Do you understand that, Mr. Shomo?
Yes.
Thank you. I'm now going to advise all 3 defendants as to if they were to be released and violate post-release control. The adult parole authority is authorized to return you to prison for up to a maximum of 1/2 of the original sentence imposed. If you are convicted of a new felony while on post-release control, in addition to being punished for the new offense, the judge can add an additional consecutive prison term of 1 year or what time remains on your post-release control term, whichever is greater as a maximum. Next, when on post-release control, if you fail to report to a parole officer, you could also be charged with a new felony called escape. Do you understand all that information, Ms. Smith?
Yes, Your Honor.
Mr. Bryant?
Yes.
Mr. Shomo?
Yes.
Thank you. Just one moment, please. As indicated by the attorneys on behalf of at least Mr. Shomo and Mr. Bryant, the court is going to advise all 3 defendants of their appellate rights. So this applies to Ms. Smith, Mr. Bryant, and Mr. Shomo. If a case has gone to trial resulting in a conviction, or if the offender has pled to a serious offense and has the right of an appeal, strike that, and has the right of an appeal. So I'm going to read each question, and I'll address Ms. Smith, and Mr. Bryant, and Mr. Shomo. Do all of you understand that you have a right to an appeal in this matter within 30 days after the filing of the court's sentencing entry? Do you understand that, Ms. Smith?
Yes.
And Mr. Bryant?
Yes.
And Mr. Shomo? Do you also understand that if you are unable to pay for the cost of a transcript, the record, and all relevant documents required for an appeal, they will be provided to you without cost? Do you understand that, Ms. Smith?
Yes.
Mr. Bryant?
Yes.
Mr. Shomo? Next, do you all understand that if you are unable to pay for an appeal, you are entitled to have a notice of appeal filed without the payment of a filing fee? Do you understand that, Ms. Smith?
Yes.
Mr. Bryant?
Yes.
Mr. Shomo? Thank you. And lastly, do you all understand that if you are unable to obtain counsel for an appeal, counsel will be appointed to represent you at no cost? Do you understand that, Ms. Smith?
Yes.
Do you understand that, Mr. Bryant?
Yes.
And do you understand that, Mr. Shomo?
Yes.
Thank you. And I would like to correct, in sentencing Ms. Smith, the court incorrectly stated that Ms. Smith will be serving a prison sentence at Lorraine Correctional. She will be serving her sentence at ORW. So I'd like to correct that for the record. As it relates to fines, fees, and costs, the court waives said fines, fees, and costs for defendants Ms. Smith and Mr. Bryant. The court waives any fines as it relates to Mr. Shomo. As Mr. Shomo has retained counsel, Mr. Shomo shall pay for the cost of prosecution. Thank you. Thank you to all the attorneys. The court would just like the record to reflect that as it relates to Mr. Shomo, the consecutive sentences apply not only to the firearm specifications, but also to the underlying offense. or offenses. Additionally, as to count 10, the court does not impose a sentence on the 3-year firearm specification, as the court imposed 3-year firearm specification as to count 9 and to count 11, which the firearm specifications shall be served consecutively in addition to the underlying offenses shall be served consecutive to each other. Anything further on behalf of the state?
No, Judge, thank you.
On behalf of Ms. Smith?
Judge, just real quickly,
Mr. Schleckett, I do not mean to interrupt, but I forgot to say each defendant will receive credit for time served.
that's what I was going to mention. Your Honor, she's been in jail since November 12th,
Ms. Smith?
2021.
Thank you,
Yes.
Mr. Schleckett. Ms. Smith has 1,515 days.
Additionally, Your Honor, if this is the time, Brittany would like to appeal the sentence and remains indigent. We're, of course, assigned. She has no ability to hire a lawyer or pay for the cost. We're asked that you assign counsel and do everything at the state's costs. Thank you.
Thank you. Mr. Shaughnessy, anything further?
Judge, Mr. Bryant is also indigent. At this point, we would ask for a call counsel to be assigned as well.
Thank you, Mr. Shaughnessy. Mr. Fallon?
We'd also ask for a transfer to the state's expense.
Thank you. Mr. Jordan?
Thank you very much, Your Honor. 2 things. One, I'd ask the court to consider that my client is indigent. He's been in the county jail for over 4 years now with a life sentence. He does not have the ability to earn sufficient income to pay the court costs of this matter. And then secondly, we'd ask that this honorable court find him to be indigent as to an appeal, assigning counsel, as well as a transcript at the state's cost. Thank you.
Thank you. The court notes your request for the record, Mr. Jordan. Anything further on behalf of the state?
No, Judge, thank you.
Thank you. We are adjourned.